And Jeff, I think what we'll do, if you don't mind just doing like your overview, you know, presentation, like your general overview, and then we do have some people that submitted questions in advance, and then we can also take some from the team at the end.
Yeah, I mean, this whole thing is going to be driven by their questions, so they should ask questions throughout.
Oop. Hi, everybody. I put some notes in the chat. We'll wait just a few more minutes for others to join, and then we'll do a little introduction and get rolling. While we're waiting, I'll just let everybody know that Jeff's located back in the DC area. He has been an association attorney for a long time, working for a big firm. And then, Jeff, you peeled off maybe 3 to 5 years ago, something like that.
5.5, yeah.
Yes. Yeah, 5.5. Okay. Um, and he often speaks at CalSAE events along with a lot of other industry organizations. And I asked him if he would well, you offered to do this, and we said yes, please. This session because he has one of the sessions that I always love to attend because there's always something new in the association world that has to do with legal stuff, and Jeff has answers for all of it and works with a lot of big organizations. So with that, and we're going to have Jeff people slowly trickling in here. But I think I'll pass it to you. So thanks, Jeff, for joining us and for doing this presentation today. As I mentioned, we have some legal questions that were pre-submitted, but then we can take questions from the floor, if you will. And if I know that you're just going to do kind of an overview, and then we'll kind of go from there. So I'll pass it to you.
Thank you, Kirsten. Good morning, everyone. I guess it's morning for you guys, right? I am Jeff Tenenbaum, managing partner of Tenenbaum Law Group. We are a 6-attorney boutique firm located in Washington, D.C. All of our clients are trade and professional associations and other nonprofit organizations. We serve, for most of our clients, as outside general counsel. So we deal with a broad array of all of their different legal issues. We have hundreds of association and nonprofit clients, primarily national organizations and international ones. I spent 20 years of my 30-year career in a large law firm called Venable, where I chaired the nonprofit practice for most of that time. I've been doing association and nonprofit law my entire 30-year career, all of it in private practice here in DC. And so there is not an association legal issue that I have not dealt with and seen hundreds and hundreds of times before, and my colleagues as well. So anything that you ask about is probably something that I've dealt with tons of for tons of different clients over the years, and will be able to give you hopefully some good insights and practical takeaways, do's and don'ts, practical tips, guidance, suggestions, etc. So this is all going to be driven by your questions, and also just a small enough group. Just unmute yourself and chime in with questions, including follow-on questions, or if you have specific examples, things that you've seen clients do that worked well or didn't work well, feel free to chime into the discussion. I'd like to make this as interactive as possible. For some questions, I will likely take a few minutes just to give a little of the legal background and context to kind of set the stage before I dive in and answer your specific question. And for others, maybe not. It just will depend on the questions. And so with that, Kirsten, did you say you had some questions that were submitted in advance? Do you want to start with a couple
Sure.
of it?
Sure. Deb, do you want to do yours or do you want me to read it?
Yeah, I can do mine because
Okay.
the whole thing wouldn't fit. So I had to do it in separate stages. So hi, Jeff. I'm Debbie. So recently our member companies have been asking our alliance to sign like supplier NDAs.
Wait. So just to make sure, when you say our, you mean your association clients members?
Correct.
Okay.
Yeah,
Got it.
so I'm with Laura Alliance and it's the Laura Alliance member companies that have recently, when we send them an invoice, usually it's for various things. It could be for membership is the typical one, but we also invoice for like sponsorships, for special events, for meetings. We have some test tools and certification fees that we also we send invoices for. And recently, when we send these invoices out, they're coming back saying in order to, finish getting set up in the supplier system, sometimes we already are, sometimes we're not, they're asking for this extra signature on an NDA or a code of conduct for us as the alliance to sign. And we have been pushing back at this moment. Because we basically, our legal counsel has advised us to, again, we're a nonprofit tax exempt of sorts association. We focus on the efforts to help the membership, and the technology, but we can't in good faith sign something like that because we can't enforce it with all of the members out there, right? We're just the alliance. And so we've been pushing back on them, sending a couple pieces of, this is why we can't do it. And so far, nobody said, okay, like, no, we absolutely need this. But my concern is it's starting to come up more and more. And, do you see this something that's becoming standard practice in the industry? And if it is required to sign an NDA or code of conduct, what is the risk to our alliance or an association if we sign those when we really don't have any way to put that onto all of our members that are out there? Because again, there's no way for us to do that.
Okay, a few thoughts, all related but different thoughts. First off, I've never even heard or seen of anything like this. With a member who's sent an invoice, sending the association, their membership association, a code of conduct that the association has to sign or an NDA. I've just never heard of anything like that. I don't understand the rationale. It makes no sense to me. Like someone's clearly lost it there because it's illogical. It makes no sense. It's almost, it's one thing we get the requests, for the W-9 forms all the time, before
Oh,
like
that's
a
common.
can pay us, that's common. And sometimes they want your account information so they can set you up for electronic payments. But other than that, that's it. I've never heard of anything more than that, and that's just it's ridiculous.
So I
Second,
think the uniqueness with our group is they kind of look at us as, we say, well, we're not supplying any products, right? And so we push back on them saying, again, we're an alliance, we don't supply any products. However, we do provide them with what the board has created as like a net ID, which is like a net ID that they use that attaches to, technology that they're using or a product that they're using. And so I think, maybe with other groups, again, we're not supplying a product, but we are supplying this
But
net.
it doesn't, I mean, every association supplies services, right? That's what you are. Once in a while, products as well, but usually services. I mean, you could call it a product if it's an educational course or something, but most people refer to it when we do trademark registrations for associations, we always refer to the association services and describe what they are. So every association provides services, but you're the service provider. I just don't understand why you as an association would have to agree to a code of conduct or an NDA and why it would even be needed. It makes no sense. I mean, if they want some sort of guarantee that you're going to keep their payment information confidential or something like that, that's a different issue. But again, I've just never heard of that. That's number one. Number two, you always have to distinguish, and we do get into this in other contexts sometimes. We get into it sometimes in hotel contracts, uh, hotel and convention center contracts where, say, the hotel wants the association to indemnify it for the acts of all of its attendees. So, like, if any attendee, does some damage to the hotel or whatever, that, the association is going to indemnify them for those damages. And sometimes it's even broader than just damages, it's other things too. And, like, let's say an association attendee or a member, sexually harassing a hotel staff person or something. And, we push back because we're like, the association can control its own staff for sure. You know, maybe arguably it can control its own board, but generally we try to limit any legal obligation or liability, whether it's indemnification or otherwise, to only those folks that you can control, namely people who are your agents, which is namely your staff. It might sometimes be certain contractors or sometimes certain officers or directors, but it's generally going to be your staff because you don't want to be on the hook for things you can't control. Um, and so here, if and let's say there was some logical or important or necessary reason for this documentation to be signed, if you could limit it to just the association kind of acting through, in your case, the management company, AMS, that's one thing because you can control that. But you want to limit it by its terms so that it's not applying to all of the members of the association. Does that make sense?
Yes, okay, so what we have been doing has been, what our legal has also advised is, it's not something we can sign.
Right, but I'm saying if you could understand and figure out that there was some logical reason for it, then what I would do is I would negotiate the wording of it so that it only applies to the association and its management company staff, not to the association's members or board members or things like that. Because you obviously can't bind them to that.
Debbie, can I ask a question? Is it a US based member?
No, it's,
Yeah.
no, it's international. Yeah, it's
Where?
like they're trying to implement, more of that within their company and their suppliers. Having that code of conduct and implementing that onto their suppliers. But again, we always go back and say, we're not a supplier.
Where are they
But
based?
you are a supplier though. Maybe not in the classic sense, but you're supplying some services. And if they want, for instance, I guess this could be let's say you are like we have association clients that do go on site and conduct training, like on-site training services and how to do certain technical skills in training, sometimes train the trainer, just whatever. Point is, associations sending, usually it's not staff, sometimes it's staff, more often it's an independent contractor that gets hired to go out and do training on behalf of the association, right? So the client hires the association to do the training, association sends either, its staff or its independent contractors or agents of its out there to do the training. And a lot of times in these contracts, the client wants some like there, they might include a code of conduct to say that you association represent and warrant that your agents, whether employees or contractors, agree to abide by this code of conduct. Things like you're not going to sexually or racially abuse our attendees, our folks who are attending the training session or things like that. Or to the extent that you learn things at the training from our attendees, you're going to agree to keep it confidential. Right. So that has some logic to it in a situation like that, particularly if it's an in-person transaction. But I could probably come up with some factual examples where even an electronic virtual transaction could have some need for that. And that in that situation, I think it would be got devil's in the details. I'd want to see the terms, but it would probably be fine to sign so long as you're limiting it to the people you can control, namely your own staff and not anyone further. So I think really that's, Debbie, where I would make the focus. Of course, if you can just say, no, we're not signing it, and they're like, okay, that's fine, we'll go ahead. That's great. But there likely is going to come a case where that's not the case, and you don't want to give up the revenue. And I'm just saying there's probably a way to make it palatable.
Yeah, right now it's not, we're not having any of those cases. It's just simply kind of like, this is their standard package of things to do related to an invoice that goes through their system for processing. So as you said, if it's a different situation, then yes, there'd be follow-up questions of, what is it? Is it somebody traveling somewhere? But we haven't had that right now. It's just a basic invoice. They're not even that much. It's more of kind of just a package of when you're submitting an invoice in their portal, in their system, they also want these things signed. So as I said, they haven't been, when we say, no, this doesn't pertain to us, they haven't been pushing back. We're just getting more of them more often than, so I was just curious if you've seen this in the industry as a new practice that companies are doing. And again, most of the ones, it's just been a handful and they're all international companies.
Yeah, no, I have not.
I'm sorry.
Kirsten, you got more?
Yes. This is Flor, and we actually did receive a similar thing from a US-based member. Our association received, actually, and it's not new this year, we received it back in 2022 as well. And basically what it is for us to keep our account active in their payment portal and to be an approved vendor for them to be able to pay any invoices that we send out. They require that we sign this. It's an NDA, but the way I read it was it really applies to the association, not particularly to the individual companies, but more of the administration. We don't have
and that's by the way, it's any contract, anything like that says it's binding the association. That generally means, like, an association is an entity, but an entity acts through its agents, which are generally employees and sometimes, like board members or officers and sometimes independent contractors. And so if it just talks about the association being bound by an NDA and assuming you can keep the information confidential, I would not be concerned about that. By its own terms, when they say the association, that is not binding your members, because those are not agents of your association. They can't legally act in your behalf. So if that's all it is, I would not overblow this. And it sounds like pretty much a non-issue.
And I hesitated at first, but then we ended up signing it. We actually renewed it this year. It's only one company from all of our membership, but it is US based. And, it's very, it has some high security areas of their work. And I thought maybe that was part of it too, that they work with pretty sensitive information and maybe, but that was the only request that we got.
That doesn't concern me at all.
Mm-hmm.
All right, what else do you have, Kirsten?
Let's see. Okay, this is one that was pre-submitted also, so I'm just going to read it. The question is related to filing a 501c3 versus a C6 exempt filings. If an organization is not open to the public and the focus is on networking and mentoring, but does not intend to charge membership fees or doesn't have a common goal on behalf of a company or industry like other associations that we manage, which exemption category would most likely apply?
Yeah, unfortunately, there's not enough information there for me to be able to answer the question spot on. If whoever wants to follow up, I can give you more details, but I can give you a few kind of principles, guardrails, things like that to keep in mind.
Okay.
One is that, this is federal corporate income tax exemption. There's all different types of tax exemption. There's federal corporate income tax exemption. There's state, like California franchise tax exemption. There's California sales and use tax exemption. There's California property tax exemption. So when you say exempt from tax, you have to specify what you're talking about. Here we're talking about federal corporate income tax exemption. As you know, there's about 30 categories of exemption at the federal level. For associations, the two most common are 501c6 and 501c3. For ASAE did some research a few years back, and they determined that of all the membership associations out there in the country, both federal, state, local, that about 2/3 of them, the principal association is exempt under C6, and about 1/3 are exempt under C3. Now, these days, with new exemption applications going through, it's less common for the IRS to recognize C3 status for a membership association. Used to be a much more common thing in the past, especially for associations in the medical space, scientific space, education space in particular, groups of, medical professionals, doctors, nurses, etc., teachers, scientists, stuff like that. Nowadays, for membership associations like that, where the principal purpose of the association, regardless of what profession it is or industry, where the principal purpose is to further and advance the profession or the industry, the IRS is going to try to push that into 501c6. But that wasn't the case in years past, and the IRS is not going to go around and just start revoking the exempt status of those C3. So you do see, and we have a lot of clients that are C3 membership associations. Think like American Chemical Society, and so many others that we represent. But the point is that if it's a membership association whose principal purpose is to further and advance the profession or the industry, it really should be put into a C6 box. Whereas if it is an organization whose principal purpose is to promote a public benefit, like to not necessarily the entire public, but a segment of the public, as opposed to advancing an industry or profession, then it might qualify as a C3 if it also meets certain other requirements, such as it has to be either charitable or philanthropic, educational, scientific in terms of like research that's available to the general public, or religious. Those are like the four main categories that for C3 qualifying. But it's not just, you got to check a lot of boxes to be a C3. It has to have primarily public more than private benefit. It has to fall into one of those categories, charitable or philanthropic, like helping the poor, the disadvantaged, educational, think colleges and universities, scientific, think research institutions, or religious. But then it also has to not have impermissible private benefit. It can't have any private inurement. It can't do too much lobbying. It can't do any political campaign activity. These are some of the other requirements to be a C3. Sometimes it's a little bit unclear in what category it would fall. Sometimes, to make it more complicated, there's another category called C4, which is very similar to C6 in most respects, but it's a little bit different. And one of the requirements, there are other requirements to be a C6 as well. One of them is that you have what's called a meaningful extent of membership support, which the IRS generally defines as financial support from either members or the functional equivalent of members, like certificants or accreditants for a certification or accreditation program. And the IRS does look at that. That's part of their checklist for a C6. So if like it has members, but they're not paying any dues, or certificants aren't paying any fees, and the money is just coming from other things like corporate sponsors or an endowment or something like that, investment earnings, it probably would not qualify as a C6, but it probably would qualify as a C4. C4s are called social welfare organizations. Sometimes they resemble a C3, sometimes they resemble a C6, and they're also used these days a lot for like political expenditures, like independent expenditures, like running issue ads around campaigns, political campaigns that don't expressly call for supporting or opposing a candidate for public office, but that come close to that line after the U.S. Supreme Court Citizens United decision a number of years ago kind of opened the door to that under campaign finance law. And so federal campaign finance law. And so there's a lot of C4s out there for that. But just keep all of that in mind. And then if we didn't want to make it complicated enough, I'd say the vast majority of our C6 association clients have a related C3 affiliate. what we usually call a related foundation. It's essentially, it's not a subsidiary per se, because a subsidiary means ownership, and a nonprofit corporation has no stock, so it can have no owners. But it can be controlled by another entity. And so, like when we set up a new C3 foundation for an existing C6, we set it up as a controlled affiliate with a lot of control by the C6 over the C3. We generally like to make the C6 the sole member of the C3, giving it the ability to appoint and remove all of the directors, all of the officers, ability to approve any amendments to the Articles of Incorporation and bylaws, ability to approve the annual budget, things like that. Certainly the ability to approve a merger, consolidation, dissolution, or transfer of substantially all of the assets. And so we like to maximize the control while still keeping corporate separateness, still having some independent board members on the C3 board, even though they're all appointed and can be removed by the C6 board, things like that. And by the way, on a lot of these topics, maybe not the first one because that was so esoteric, but all of these tax-related topics and other things, on our website, we have a ton of resources, hundreds and hundreds of articles, PowerPoint presentations, and recorded webinars on all these different issues. We have a great one on related foundations of associations. We have a great one on unrelated business income tax, other stuff. The website is tenenbaumlegal.com, tenenbaumlegal.com, and there's a resources tab where you can see all that stuff. There's also a great search engine that you can search for stuff like that. So I'd encourage you, or always just feel free to reach out to me and shoot me an email and say, do you have anything on this topic or that topic? And we have also a number of resources that are not on our website that we can share as well. Tons of like model association forms, policies, agreements, things like that. Always happy to share that.
Awesome. Thank you. I have another question unless somebody from the floor has something specific. So AI, Jeff, is, in play. So can you tell us maybe a little bit about, as an association, what we should be aware of in terms of data privacy and utilizing AI within our organizations, and how that's affecting associations today?
And as you know, it's affecting association lots and lots of different ways. And I'm not going to speak to the technological aspects because that's not in my wheelhouse. And what are opportunities for associations to better utilize AI and everything it does. And so many associations are using it quite interestingly and innovatively and successfully in so many different areas. In some ways, some people are concerned about the effect on jobs, but it's here to stay. It's not going anywhere. It's already replacing jobs, but what it's also doing is it's taking away some of the more menial aspects from some association staff's jobs and forcing them to kind of elevate their skills to work at a higher level, and let the AI do the easy stuff or the first cut at something, or the things that used to take a lot of time with sorting and analysis and things like that, where maybe you don't have to have a human being do it, but then have the staff person bring more creative and analytical and being able to apply the end result to figure out how to do the most with it, monetize it, other things like that. To me, the from a legal perspective, the most important thing is for every association and probably every association management company like AMS to have an AI employee usage policy to say, look, we're not going to, it's like back in the old days when I started practicing law and there was some, management at some associations that wanted to like ban employees from using social media during work hours. I mean, can you imagine something like that these days? It's just not going to happen. Or, to ban people from using, Google and whatever the other search engines were back then, to help them do their work. I mean, obviously that is a non-starter. And frankly, AI is quickly becoming the same thing if it hasn't already. And will become even more so because it's that much more effective. So it's not about whether or not you're going to use it. People are going to use it whether they're allowed to or not. It's more, there is a lot of legal risks that come from it. And you need to manage those risks in order to help protect the association from those risks. So what are some of the bigger risks? You or whoever the questioner mentioned, privacy and data security, right? So if you're using like a typical AI platform, like, a typical non-modified version of ChatGPT or something. Whatever data you put into that platform, the platform is going to use it to train the entire platform. It basically goes in and then goes everywhere else from that platform to help it get better, to help future searches. And there's a very real potential that whatever you put in there is going to show up in someone else's AI output, what the AI platform spits out. And that's very disconcerting if you're talking about sensitive, confidential, or even privileged data. But whether it's personal data, whether it's health data, whether it's financial data, whether it's member data, personal contact information, that can be really dangerous. And so, but there are different ways you can manage those risks. You could just have prohibitions on people putting certain data into an AI platform. But two, there are enterprise versions of AI platforms where, like AMS, for instance, could subscribe just like you do for Outlook, right? You get a license for all of your employees to be able to use Outlook, and the whole Microsoft, portfolio of Word and Excel and everything else, and you pay a per person license fee, and then you can customize that enterprise version of it with all sorts of rules, that allows you to do this or doesn't allow you to do that. We realized something in our Microsoft platform was prohibiting our people at our firm from doing certain things. And so, but we were able to change that and lift that restriction. You can, if you have an enterprise version, you can set it up so that everything that goes into that AI platform never goes out. It doesn't get used to train the platform. It just kind of stays in-house. It used for the output that comes back to you, but it doesn't go anywhere else. There are also like individual paid versions of certain of the platforms where you can elect to turn off that sharing feature. Now and if you're talking about like an employee policy, certainly you can have that in your policy, but the practical reality is some people probably aren't going to follow it all the time. They're going to forget, or they're just not going to care, or whatever. And so, it's really too soon to say what kind of trends are going to evolve in this area. Um, but if you can afford it, having some kind of enterprise version that you ensure that nothing that goes in is ever going to go out into the ecosphere or whatever, it's just going to stay in-house. And you require employees that any time they are using AI for anything work related, they have to use the enterprise version, right? They can't just like pick up their phone and start, doing their own AI stuff on their own. That's a realistic option. For some small associations, they're not going to be able to afford that. And so then you just have to try to regulate employees' conduct with those things. Another area that generates legal risk is in the employment space. So this is really more something we're seeing with larger employers, but a lot of larger employers are using AI all the time for all different aspects of the HR function, including for searches. And we just did a search for a new paralegal at our firm, which we just hired. She officially signed yesterday. Phenomenal hire. Super excited. But I just got the final analytics from LinkedIn. That's the only place we use to post the ad. And there were like 5,000 plus views of the posting and 1,350 applications. Right? That's a lot of applications. That's just for our 9-person law firm for one paralegal position. Think of a larger group that's going to be posting even a lot of other places. It's not inconceivable. You get thousands of applications. And think of the time, we had our office manager, Stevie, was the one who went through those, all of them. She did it on her own without AI, at least as far as I know. But, if she could use AI, it would, looking for certain key things, certain key experience. We got a lot of applicants that were just not qualified for the position. It's very enticing, and a lot of employers are doing it, to use AI to weed out those resumes, even sometimes to weed out the cover letters. Some larger employers are using AI to weed out the resumes and the cover letters, and then having, say the top 20 candidates do recorded interviews of the same questions, ask the same questions, and then they use AI to screen those recorded interviews. You can imagine all of the potential bias that's built in, because the AI is built on like what's out there on the internet and whatnot, which anyone who knows anything about searches, will tell you that, yeah, there's all sorts of bias built in to what comes back from searches. And so by definition, there's going to be bias built in to these sorts of functions. And that can lead to employment discrimination, a liability for the employer to be really serious. And so you have to find a way to have some sort of a human element to screen and try to screen out that potential bias. Things like that. Another area I could go on, I've done like hour and a half webinars just on this topic, but real quickly, two other areas of potential risk. One is copyright infringement. There's all sorts of litigation going on right now, from artists and others who claim that their works are being infringed by AI. Yeah, I was just watching last week with John Oliver last night, a recording of it, and he was doing a story about AI and the way it's generating all these fake images and videos and things like that, but how it's also infringing on artists, who develop sculptures and paintings and things like that, because AI finds that and then does their own version of it, and it weakens the market for that artist's product. We see it with music, we see it with movies, TV, everything else, books. And so one thing you want to do as an association is make sure that your use of AI doesn't lead to any copyright infringement claims against your association. And there are ways to screen things, there are tools to check if something infringes people's others' copyrights. And you want to, again, through that employee AI usage policy, make sure that you're requiring your employees to do that sort of screening to help minimize the risk of copyright infringement. Just like, years ago, kind of in the advent of, the internet's more widespread use in the workplace, I had to start telling associations generally that just because something's available on the web, whether it's text, a newsletter, an article, photo, video, doesn't mean that you're free to just put it in your association's newsletter and send it out to your members. In fact, there's tons of copyright infringement suits that happen through stuff like that. And there are law firms who make a lot of money just going out and trolling for this stuff and then sending very expensive demand letters demanding thousands of dollars in damages for the use of those infringing materials in it. And a lot of times they have a very strong case and we have to try to negotiate a settlement for our clients. So that's another example of risk. And then the final one I'll mention is tort liability. So to the extent that your association is, say, developing standards, or it has a certification or accreditation program, or putting out, clinical practice guidelines for medical professionals in a given space, or, anything that either the members or even the public are going to rely on to do their jobs better, or to carry out a certain procedure, to do whatever. Anytime that you as an association put out that sort of guidance, even if it's just voluntary guidance, not like mandatory for your members, if you get something wrong, and if you are negligent, you get something wrong and someone relies on that guidance and it causes injury or harm, bodily injury, property damage are the two most typical types. You can potentially, as an association, be liable for negligence for that act or omission, whatever leads to the negligence. And there is a real concern that I've seen that associations, particularly staff or volunteer leaders, who are developing that sort of guidance and relying on AI to help create that guidance, but not doing the proper human vetting necessary to be sure that nothing in there is negligent. That's another area of significant legal risk for associations that get into those sorts of activities. So why don't I stop there? If anyone has any follow-up questions on that, let me know.
I have a question about just tagging on to what you just finished on the tort liability. Is there that's specifically in regards to using AI and not vetting it properly to make sure that you're not just pushing something out that might expose,
tort
right?
liability has applied for decades and decades, well before AI. In one of the articles I wrote 15 years ago was how associations can mitigate their tort liability risk. So there's always that risk, and it's generally risk of negligence. Right? Like there was an association probably 20 years ago, the National Spa and Pool Institute, that used to put out voluntary standards for appropriate residential swimming pool depths where there was a diving board. And one of the members, manufacturer of swimming pools and the diving boards, relied on that guidance, built pools with those pursuant to those standards, those depths. And a teenager, dove off a diving board, hit his head on the bottom of the pool and was paralyzed, full paralyzed for life. And the family, or might have died, I can't remember, but the family sued the manufacturer, but they also sued the association that had issued the standards, claiming that they were negligent because look at what happened. And sure enough, they won the suit and they won multi-millions of dollars, and the association ended up going bankrupt as a result. And so that was, well, it has nothing to do with AI, but I'm saying if you were
No.
using AI to help calculate appropriate swimming pool
Right.
depths, you can see where there's a real danger there.
And then for that kind of exposure, is there a specific kind of insurance, or what would you do to help mitigate
Yeah,
that?
I was literally just going to say that. That's a great follow-on question. So yeah, insurance is so important for associations, so important. And I review a lot of insurance policies. I counsel clients on insurance. Seems like every other day I'm reminding clients to notify their insurance carrier, because if you fail to give timely notice of a potential claim, you can lose coverage. But, a few things about insurance that most people don't know. One is that, yes, there are kind of the standard types of insurance policies that most associations could have, but they're not all the same. Like some of them, like property insurance and commercial general liability insurance, they're pretty standard. Most of the carriers have the same standard policies for the most part. But other types of insurance, like cyber insurance and directors and officers liability insurance, which includes the employment practices liability coverage, and then the errors and omissions insurance, sometimes called media liability insurance. Those are not standard at all. They really vary significantly from carrier to carrier. And then depending on the nature of the association's activities, the policies are going to be have certain endorsements or like amendments added to them. So for instance, if you're an association that does a lot of publishing, book publishing or journal publishing or things like that, your D&O policy almost certainly is going to come with an endorsement, an amendment that says that the policy will not cover any claims arising from your publishing activities, copyright infringement, defamation, invasion of privacy, tort liability, things like that. And so that's a big problem, right? If you're a publisher and you don't get coverage there, so you either have to do one of two things. You need to try to find a way to pay enough in premiums to buy back that coverage from the carrier, or more likely go out and get a separate errors and omissions insurance policy, which are designed to cover those sorts of risks. They're also designed to cover, like D&O policies won't cover what they call professional services, like consulting services or other things like that, technical training services, on a one-off basis. And so there, again, you need an errors and omissions insurance to cover that. D&O policies also, by their terms, they all exclude claims for bodily injury and property damage. So if you're doing things like the certification or standard setting where negligence could lead to a claim for bodily injury or property damage, you have to have an E&O policy to cover that, because your D&O policy is just not going to cover it. And that's one thing. Two, you want to work with a very knowledgeable insurance broker that really understands the association space. In my experience, the vast majority of the insurance brokers out there don't know this space. And you have to know the space so that you really understand what are the core activities of associations, what kind of legal risk do those generate, and then what sort of policies are out there along with endorsements and whatnot to best mitigate those risks, that best maximize the coverage and minimize the coverage gaps. Also, the importance of giving timely notice so that you don't get denied coverage. And I could probably come up with 25 tips, but here's one more. On the employment side, and for your clients, your association clients, I guess this isn't relevant because they don't have their own employees. But for those that do,
Some do actually. So some have like
you
paid
do
presidents.
for certain things, yeah. So the vast majority of claims filed with D&O insurance policies are employment-related claims, the vast majority. And that's in our experience, in our practice too. And one of the things that a lot of associations don't know is that once, the insurance carrier is kind of on board and they issue a coverage letter, they always reserve their rights to later deny coverage. But once they issue a coverage letter, you cannot make any significant decisions about the case without clearing it with them first. Otherwise, you risk losing your coverage. So like we had one client about 2 years ago that, they put the carrier on notice. The carrier said, yes, this seems to be a covered claim. The association went back and forth in negotiating a severance agreement with the employee who they were terminating or had terminated. In the end, they couldn't come to an agreement. The employee was asking for way too much money and ended up filing suit, getting an EOC charge and then filing suit. And the insurance carrier came back and they said, whatever your last offer was, I think it was like $100,000 or $75,000, whatever your last offer was, we're not going to cover that amount because you made that offer without running it by us, and that kind of prejudiced us. And that was a big blow to them. I think we're able to end up negotiating something in between, but bottom line is make sure you include the carrier, even if it hasn't turned to litigation yet, just in the settlement negotiation, if you want them, because we can usually get them to cover the settlement amount less your deductible, if they agree it's a covered claim and they've given you that coverage letter. But, if you don't run things by them, there's no way they're going to cover it.
Okay. Thank you. I have another one or two, but does anybody else have anything?
I was just
Lise?
curious,
Yeah,
if
please.
I could, like, what are you seeing as the most commonly filed suit against nonprofit 501(c)(6)? Like, where do you see the most
Employment suits by far,
employment?
employment-related suits. But, other ones that we see a lot, copyright infringement. And I'm not talking about like the small stuff where you get these demand letters from lawyers. That usually doesn't turn to litigation. They always threaten it, but usually gets settled. But bigger copyright infringement claims, we had one that was litigated in federal district court in New Hampshire a couple of years ago for a longtime client of ours. We see claim suits once in a while relating to certification or accreditation programs, particularly by people who get denied or revoked their certification or accreditation. Sometimes making antitrust claims, defamation, tortious interference.
Can you speak a little bit to that in terms of, because some of our groups do have a certification program in terms, and so when they're in the process of usually using a third party certification house, to make that call if the company that's applying makes or makes it to the certification level or not. Is there any other issues you see
So
there?
they completely outsource that decision-making process to another company. Like, they don't have like a certification board comprised of volunteer leaders or something who makes those judgment calls.
Some
Okay.
do.
Can I just clarify? I think the association, Jeff, comes up with the framework for
Criteria.
which the certification terms are, like what is required to become certified, and then then the testing of it they give to a third party test house. A lot of times it's software or equipment to do that.
Yeah, and then that's very common. But usually, like if we're talking, say, professional certification of professionals, there's usually going to be multiple elements to the certification requirements, right? You have to be practicing in a certain field for a minimum number of years. You have to, if there's a testing component, you have to pass a test with a minimum score, maybe certain number of years of work experience or educational experience, with a degree in a certain field. And I would not have had any professional disciplinary actions taken or criminal, convictions in the field, or maybe just generally. Like, we've seen all sorts of things like that. And so while the testing might be outsourced, the final determination of looking at all of those requirements, going through, checking the box, including things like with the trickiest stuff has to do with disciplinary matters, people who have acted badly in certain respects. That I've never seen outsourced. Like that's usually a group of volunteer leaders, a
Yeah.
certification board or committee that makes those final calls, maybe with input from staff, or an outsourced vendor. But anyway, look, in this area, regardless of whether you outsource it, maybe that provides you a little bit of extra protection on the testing side. But beyond that, the risk is primarily on the association. And I'd say the core things that you want to do in any certification or accreditation program, and the same, by the way, applies if the association has an enforceable code of ethics. Enforceable code of ethics, not an aspirational code, but if it has an enforceable code, it's all the same basic body of law that applies. And we're usually talking about the primary risks are in antitrust, particularly for a group boycott, tortious interference and defamation by people saying their reputation was harmed, it hurts their job prospects, they lost their job. And then in the area of tort liability, that someone hires this professional because they were certified, turns out they don't know what the hell they're doing, and then someone comes and sues the association for negligent certification. We don't see that often, but there have been a number of cases in the past. And the same thing can go for a code of ethics. Association says, you should hire professionals in art who have, who are, show that they're a member of the association because it means they abide by these really high standards in our code of ethics. But it turns out the association really doesn't do much to enforce them at all and turns a blind eye to a lot of stuff. And then someone, again, hires them. Because of that, they get injured and then they end up suing the association. So what do you want to do to mitigate against these risks? Well, first off, you have to have the standards themselves, the core requirements. They're really important and they have to be reasonable. They have to be objective, not too subjective. They have to be clear, like not ambiguous. They have to be reasonable. They have to be, related in some way to some, purpose of the job. They can't just be out of left field. I think the areas where we see the most problems are when the standards themselves, the requirements are too vague or ambiguous or subjective. That's when it can get dangerous. And we actually see, I said certification, accreditation, and enforceable code of ethics, but it also applies to membership itself in the association. Some of these same risks can go for membership, particularly where membership is more selective. We've seen some cases where like a member who gets denied membership or kicked out of membership sues the association for antitrust claims, claiming a group boycott or something. And I've seen it a lot, especially with smaller state and especially local associations. Sometimes they'll have a membership committee that votes on who gets in as a member and who doesn't. And they're very subjective and they're kind of voting on who they like and who they don't like. And that can really get you into trouble. So you really want to try to eliminate as much subjectivity and ambiguity as you possibly can from both the standards themselves as well as the application of those standards to, how these decisions get made. You want to make sure you're regularly updating the standards with input from all relevant stakeholders. So you make sure you got the most up-to-date information technologically, scientifically, otherwise. You want to make sure that you are administering the program on a consistent and objective basis. Again, try to take that subjectivity out of it. Sometimes it can be difficult to apply some of these standards, particularly when it comes to say it's just a membership, say a trade association, a membership in the association, and the bylaws have a provision that says that members, businesses who have gotten into certain financial or legal trouble are not eligible for membership. Of course, I'm not wording it artfully, but you can imagine no matter how you word it, there's going to be some subjectivity involved. There's going to be some ambiguity. There's going to be sometimes where a member company or the owner, had to file for bankruptcy and did end up screwing over certain customers, but it was of no fault of his or her own, right? So how do you deal with those things? It can be really difficult and subjective sometimes. So sometimes it's impossible to make it as objective and consistent as we would like, but you want to get there as much as you possibly can. And then I think the last thing I'd add is due process. Courts like to see due process because they're used to it, because that's what the court systems are all about. So, giving people, if you're going to take some adverse action, whether it's denying certification, denying membership, censuring them through a code of ethics, banning them from conference attendance for a certain period of time, banning them from membership for a certain period of time or forever, any adverse action, give them a right to defend themselves. Give them a right, if they want to have legal counsel, at least gives them some reasonable opportunity to defend themselves. And then if you can, particularly for whether it's certification or a membership that's more valuable economically, build in some appeal right, to the board, to the executive committee, to some other appeals board, whatever. And you can craft the appeal process so that it's more limited. It's not like a whole second bite at the apple, not like a whole new trial, so to speak. But you can do it on a more limited basis, but you want to build in some appeal rights as well.
Thank you.
That's good.
Yeah.
Anybody else? I have one last one that always gets asked, unless somebody has another one. We are constantly asked over and over again, I think, by our clients and the staff wanting clarity on contractor versus employee. And maybe you could just touch on that. I know, many of our associations are incorporated in California. Some are in Delaware. We may have, I think we have one that's in Colorado, whatever. So if you could maybe just talk to that, and then, the difference between where the entity is incorporated, but also maybe where the employee and or contractor is located and how that plays out.
Yeah, that's a great question. A few things. First off, where you're incorporated matters for certain purposes. Like, for instance, regardless of where you're located now, wherever you are incorporated, you are governed by that state's nonprofit corporation statute. And every state nonprofit corporation statute is different, has different rules, requirements, prohibitions, restrictions, word things in different ways. Some say that if a board member was elected by the members, that no matter how much bad stuff they do, they can only be removed by the members who voted to elect them. Whereas other states don't say that. Most of the state statutes say, by the way, an officer who was elected by the members can be removed by the board. We deal with a lot of cases, this is an aside, of board members and officers acting badly. So much of this happens at conferences and meetings, often 90% of the time with alcohol involved, and so many stupid things that happen. And we, deal with the fallout from them. But that's one instance where, because someone says, what, this guy, he's so off the charts, he's been so bad, we just got to kick him off the board. But he was elected by the members, and you look at the state statute, and it doesn't allow for the board to remove him no matter what he did, even for cause. So you got to consult your state statute. Oh, another example in California, you can only be a board member if you have voting rights. So you can't, for instance, say that your CEO is an ex officio non-voting member of the board, because they're not a board member unless they have voting rights in California. But that rule is unique to California's nonprofit statute. No other state that I'm aware of has that provision. So where you're incorporated matters for purposes like that. It does not at all factor into this question. So it has nothing to do with it. Whether you're incorporated, if you're incorporated in California, but I'll give you the opposite example. So say the association is incorporated in California, but the individual, I'm going to call her the worker, because that's the term that's usually used, kind of the generic term if we don't know it's an employee or an independent contractor. The worker is located in Nevada, and it's a remote work position, right? Even though the association is headquartered in California. Well, say it's incorporated in California and its technical headquarters is California, but it's really a remote association. I will say, generally speaking, the employment laws are going to apply based on where that employee is principally working from. And I say generally because there are a few exceptions. And there's also an open question on this particular issue in California as to whether, if like the employer is headquartered in California, but it's a fully remote position in another state, does California's law regarding independent contractors versus employees apply or not? And there's some dispute about that in the courts. But generally speaking, most of the employment laws apply based on where the worker is primarily working from. And as I'm sure you know, California has the strictest law regarding independent contractors in the country, which makes it really, really difficult to have a lawful independent contractor and not treat that person as an employee. And this is regardless of whether it's part-time or full-time, doesn't matter. You know, basically, and this is a gross simplification of the rule in California, as I understand it. But if the service being provided is part of like the core functions of the association, right? You know, think meeting planning, think, you know, educational conferences and publications, membership services, things like that. If it relates to any of that, and you hire someone on a part-time basis to help out with that stuff, they're not going to be able to be treated as an independent contractor. They're going to have to be treated as a part-time employee. It's only for functions that are outside the core functions of the association. You know, say mail delivery or courier. You know, I don't know. You could come up with a million bad examples of, you know, non-core functions that don't go to the core functions of your association. Those, if they otherwise meet the test, they can be treated as independent contractors. But it just frankly makes it really difficult and a lot more expensive. And that's the whole idea. It's all about protecting worker rights. And because as you know, when someone's an employee versus an independent contractor, so there's a whole rash of protections and benefits that get built in. You know, now if it's part-time, they're probably not going to qualify for like health insurance and certain other employee benefits or 401k plan match or stuff like that. But they're still going to have the employer share, the employer is going to pay the employer share of the payroll tax, which is about 7.5%. That's a lot. The employer has to do withholding and, you know, send the withheld taxes to the IRS and the state. All of the employment laws like Title VII of the Federal Civil Rights Act of 64 and California's employment laws, they all apply to an employee, but not to an independent contractor. And workers' compensation, unemployment compensation, you know, all these different things factor in, you know, leave laws, you know, family medical leave. California has some very employee protective leave laws. I don't remember if it has a paid leave law, but all of these things only apply if someone's an employee. And also, like, employees are deemed to be agents of the organization. So everything they do can create liability risk. Basically, it's a lot worse off for the association to have an employee versus an independent contractor, which is why there's a built-in incentive for financial and legal reasons to make someone an independent contractor. But if they are principally working in California, it's difficult. If they're working outside of California, like my hypothetical about the part-time employee working in Nevada, let's assume that she can be an independent contractor. Then, you know, there's a multi-factor test that applies, and there's actually 3 tests. There's 2 at the federal level, a U.S. Department of Labor and an IRS test, because this is both a labor issue as well as a tax issue. And then you have the state, say of Nevada, the State Department of Labor and the state tax office presumably have their own tests, but they're all largely fairly similar. And to me, you won't see this enumerated in any of the tests, but the most important factor to me, first among equals by far, is the person doing that work for other clients, or are they just doing it for you? To me, that is the most important test. And if they are doing the same, there are other factors like how do you compensate them, and are you paying for certain things, and do you let them use your email signature block and an email address from the association? But there are ways to do all of that lawfully and still have someone be an independent contractor, and there's tons of examples of that. To me, the most important thing is, are they doing this work for multiple different clients? If they are, then there's a very, very high likelihood they can be treated as an independent contractor. And if they're not, then it all of a sudden becomes a higher risk proposition to treat them as a contractor. And that's where I say you want to get legal counsel involved.
Okay.
All right.
Awesome.
Glad I got through that. And I cannot believe this is the first webinar I've done this year, 6 months in, that no one asked a question about DEI, which I'm very grateful for. Well, you heard me speak at the Cal
Yeah.
SAE annual meeting about
I did.
probably spent half the session on it, and that's what
Yeah.
everyone's been asking questions about. But I really applaud you guys for not asking about DEI, but asking about a lot of other really important and interesting issues. And then last thing, and I got to run to an event, but I like the fact that you asked questions about lots of different important topics, governance and tax and employment and, insurance and I forget what else, but anyway, that was good stuff. Oh, antitrust. I enjoyed that certification. So anytime you want me to come back and do this again in the fall or
Would love it.
whatever else, be happy to.
Okay. Thank you so much,
so
Jeff.
much.
Really, really appreciate it. It was great.
My pleasure.
Okay.
All right,
Thank you.
Take care.
Thank
Thanks,
you.
everybody.
bye.
Thank you.